Good morning to all. I am delighted to be here among you. And first, I am thankful to organizers, particular principal, respected principal Ruchi Chawla, and vice principal Minu Gupta, head master here, Ravi Khatru, Bhavesh Sharma, and headmaster. This is from the faculty and my associate and respected bar members, a senior lawyer and experienced lawyer, just these things just out here. So now, first I give to the faculty and this, because teachers are required to be there. So because we are also out of your teachings. So I have personally known that the speakers has spoken afterward. I have a wonderful experience. I found a picture of constitutional rights, there's civil rights, criminal rights. But we are not concerned with all this. We want how they have presented, what they have presented, what the mode of so confidence they have, faith, confidence. I have advised and I am of the opinion and I wanted that the student from law department come out with their degree after getting advocate license. They must come before the judge. They have such a capability to practice independently. Today what we are saying, a law, senior lawyer, the 15 lawyers are standing with him. They are not able to speak anything to do that. It is very, that is not. Or what is not happening? The lawyers, the advocates, they have no academic contribution of the academic knowledge. They are stopped. What happened? Once they have learned the law course, they are confined to a particular case which comes to them and they are study. And if they are from the defense side or from the other side, they are confined to a particular case. But I wanted that the lawyers who comes to a court, they must continue academic study, and the students, law students, they must have a practical knowledge, so that they should be a blend of both. So now these last I have seen this women's like you will find domestic violence. Now I was talking with a madam. I have my YouTube channel, Kanuni Church. Now the evidence you have created in this case, generally speaking, such type of evidence is not available because no one intervened when there is domestic violence. The household where she is, the family members, obviously supports the male member, husband, and the things remain inside the house. Not reported. If reported, so she will not. The court case, her case is not. But the defense we have found here, the defense in this case, what was that for money, she is being made an accused and she is being harassed. This is a defense generally created during the investigation stage, during the inquiry and trial. So I have told the madam, and there is a case of Supreme Court of India recent, and you will find in my YouTube channel. There was a domestic violence case. A request was made that obviously from the women's side who was suffering, that she has recorded the incident. But how she was tortured, how she was beaten, how she was manhandled, and how the use of force was made in the past. She wanted that video clip to be placed before the court of law, the trial court, as an evidence. But unfortunately, there is no any enabling provision in Code of Criminal Procedure and Evidence Act for production of such an evidence. No doubt, there is a provision for taking of fingerprints, but there is no provision for taking of voice sampling. She wanted that this my video clip be and her voice sample be taken so that there will be a comparison from the FSI. The prayer was refused by the trial court. Similarly, prayer was refused by the High Court, and Supreme Court then intervened. And Supreme Court allowed this video clip, let it be, and voice sample be taken of the accused, and it be compared from the FSI. After that, this was allowed. This is a case of earlier this laws, 3 criminal laws. But now in new this act, you will find now these 3 criminal laws. You find the Evidence Act, there is a provision for taking of voice sample also. So voice sample can be taken of the accused and get it compared with the specimen which is already available with any of the party. Then that can be compared, not compared from the actors. This is how these domestic violence cases remain untraced and unpunished. So this is there is a no doubt there was earlier section 14988. This is you might be going cruelty against the people. This misuse was there. Now I am going to other side. But this law should not be misused. A sister-in-law sitting in court, she is also a actor. I think there was a Bollywood movie. It reflects how there was a misuse of 498. Now, there are many, we talk of domestic violence against the women. Women's right, otherwise you will see in the Constitution, right to equality. There is a golden triangle you will find. Now, you will find after section 14, section 19, and article 14, article 19, and article 21, which the right to equality. So somebody says, why there is a reservation? Why the women are preferred by the Constitution? Our society, patriarchal society will find there is always a male dominance. So the equality is always between equals. So now we have just like SC, ST. They are giving a reservation because in order to bring them at power. Similarly, even children, why there is a pox? Why there is a child marriage state act? Also, the child, this is gender neutral, not confined to male or female. That is both of the child, sexual offense. Because they are vulnerable of the society, they are vulnerable member of the society, women and child. This traditional so thus there is an article 15, there is a reasonable classification and other given to the many laws you will find. Now there is a transgender, the person's protection right. Now it is very difficult for them to have their identity in the this there is a judgment of Nelson versus this Union of India. Came from there this transgender person's protection right act has been allowed. Many things you will find in the Constitution, in the law courts, but this justice delivery system is very costly affair. Very costly affair in now. It is very difficult to report the case at a first instance if there is some violence. Now with new law, new criminal procedure, BNSS, Bharatiya Nagrik Suraksha Sanhita, you will find there is a provision for launching of e-FIR and zero FIR. Are you knowing the students what is zero FIR? Zero FIR was when somebody wants to go to a police station for reporting, as we have done today, while there was a reporting by the women and then what happened? They used to say that it does not follow jurisdiction, you go to other jurisdiction. Then now provision has been made. The zero FIRs to be compulsory registered after that the concerned police station. Similarly, e-FIR can be lost in many offenses. Now many things. Now by today this seminar is being organized. I will come to why this type of program is needed in the law schools, in the colleges, particularly among the, because our law, jurisprudence says, the administration of justice says that ignorance of law is no excuse. I will come to. Now you cannot say that I was not knowing that if somebody commits a domestic violence, then he will say, I am not knowing the law of the land. So ignorance of law is no excuse. It means that everyone is supposed to know the law. How law can be known to everybody by doing these types of. This is appreciable. But function, I recognize, I congratulate Madam and other organizers who have done all of it. Well done by the students. Well done by the students. And this presentation was very wonderful. Or it touches as if it was a real presentation. Mr. Jasrodia will agree with me. We were feeling that the court proceedings are very similar. Not procedure adopted, not long procedure adopted in a trial. Now you have narrowed down and have 4 cases here with decision. In one of the case, I will tell you, you have not, this murder case, you have not given the punishment. Judge, who was the judge? You have not convicted, but not given the punishment. Judge, you have not given the punishment. For murder, you have convicted the accused for 304. 304 is homicide, not amounting to murder. It means that somebody is killed under provocation. Otherwise, the section, Mr. Rodia, agree with me. Otherwise, for murder, there is section 302. Culpable homicide, amounting to. Not amounting, the cases sometimes falls under. The punishment for this 302 murder is life or death. Life or death, not less than that. Yes, 304 you can have it. So this was it. Now you have mixed, I will never know. You have mixed again this case. This is a case of adverse possession. No doubt, section 308 and this right to property was a fundamental right. But we require, the government, the India requires lands for its development, and the state development, other land, now allocation of land among the builders who were active, and then the right to property was taken. There is a history, constitution, there are many rights that is constitutional judgment on this. Now it is constitutional right, not fundamental. Earlier it was a fundamental. Now it is a constitutional, the right to property was there. But It is there is also adverse possession. Now 12 years period is in limitation act. Now it is serious. But you have also included trespass. There was a criminal. In the 441, it talks about a definition of this criminal trespass. Now 447 is a trespass. Municipal authorities have allowed the construction of the shop. This was a case. Now, this was a mixture of, but I had short presentation. With regard to murder case, the defense was very wonderful that he was having this earlier injuries suffered earlier in a scuffle in earlier that. But in this case, as murder, I have seen the facts. I think the eyewitness of the occurrence was nobody. The servant who was available in the house was in another room. Nobody has seen the murder by his own eyes. This was no case is dependent upon circumstances. Such type of circumstantial evidence prevails. Circumstantial evidence is very important evidence. When there is no direct evidence, last seen duty is there. There is a last duty. When two persons are there and if one dies and accused is required to prove. They have to come with a defense that Sunil, who was from the prosecution side for murder case, and who was there, the accused has burden shift on the accused that he has to prove that how the deceased died. Because there was no eyewitness, this depends upon the circumstantial evidence. This recovery of the weapon and other things. You can say this was a blind murder case. Generally speaking, in ordinary language, people say this is a blind murder case because no eyewitness was here. There was the 3% I have already. Have anybody knowledge about the protected witness? Now, protected witness is generally in cases where there is a just like also case. The child, the victim of the offense is a protected witness. In this terrorist related cases, due to unlawful activity and this prevention of activity, you will find that there is a also protected witness. Their identity, their evidence, and their location is very important for the prosecution because gangsters behind it, and you will find they locate the man, and in many cases you have seen the Bollywood movies that these witnesses are killed, murdered, and in order to object, there is nobody, no dead body dares to come in the witness box. Nobody. Why the courts this prosecution fails? Prosecution fails because nobody comes to court. Nobody comes to court for accusing evidence, but he has seen while if the eyewitness are because they feel torture and we will have to go again and again to the court. All this is now in short. Now there is changes in now new thing in the law, and you will find a new thing. People are quite weak. I'm very glad to see that the school boys, will say high secondary level, they have presented such a wonderful wonderful presentation in short you can say from your side. I congratulate to the